All right. Hello, hello, hello. How's it going? This is immigration attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today. I have been practicing immigration law for the past 15 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So welcome to my channel. Welcome to my live. Thank you for joining. If you're a current client, thank you for being a client. And if you're a new follower or somebody who's been watching for a while, thank you for always watching and for always asking your questions and sharing your thoughts. So let's go ahead and get started. Today, I want to talk about the very, very important factor of whether or not you have enough evidence to file your case. I spoke with several people today, and also I reviewed several communications and cases where basically there was a variety of evidence in these cases. The reality is that depending on what sort of case you file, you may be worried about what sort of evidence you have and whether or not you have enough. So let's talk about what evidence is required for your VAWA case or for your T visa case. Now, if you have been hearing me talk about VAWA is going to be for those of you who are married to a US citizen who are suffering in your marriage. You're suffering either emotionally, you're suffering financially, you're suffering mentally, your spouse is verbally assaulting you, your spouse may be actually putting their hands on you. So if you need to file something for yourself because your spouse is controlling the process, your spouse is not really helping you with your case, then what sort of evidence do you need? And this is something that is very, very important. Actually, give me just 1 second. I just made a mistake about where I was doing my live. So I'm going to go ahead and fix this on Instagram so my followers on Instagram can also see me. And I apologize to all of my friends who did actually just see my live on my private Instagram, okay? Anyway, all right, so welcome to everyone who is joining me right now. My name is Moumita Rahman, and I'm an immigration attorney. I have been practicing immigration law for the past 15 years, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. So let's talk about how much evidence is enough for your case. How much evidence do you actually need to help get your case approved? And the answer to this question is actually going to be dependent upon what sort of case you are filing. Let's start out with the type of case that needs a lot of evidence to make a good impression on immigration. And funny enough, that case that requires the highest amount of evidence, in my opinion, is going to be your regular joint marriage case. So for example, if you and your spouse are filing your application together, your spouse is cooperating with you, you guys are doing this together, then actually, conversely, you actually need to have a lot of evidence in your case. You need to try to submit your case with as much joint evidence as possible. And then when you go for your interview, you need to have even more evidence to show what has been happening over the past several months since you filed your case. However, if you are having problems in your marriage, your spouse is saying that they're not going to come to the interview, they move out, they walk out on you, they abandon you, or they have filed for divorce and you're no longer with them, which requires you to look into the possibility of filing a self-petition so that you can continue your immigration journey by yourself. How much evidence do you need? You may be surprised to know that you don't need as much evidence as you think. A lot of attorneys will tell people who are suffering in these situations that they need to have a police report, that they can't file unless they have been physically injured and unless they have a medical report to document bruises and cuts and other sorts of physical abuse, which is absolutely not true. The standard of evidence as created by Congress for VAWA self-petitions is any credible evidence. That means that literally speaking, if you have anything, any shred of evidence to corroborate or support what you're saying, that can count. Also, your testimony is actually very, very important. So your affidavit is actually one of the most important things in a VAWA case. And as long as whatever you're providing and saying does not conflict with outside evidence, then it's considered to be credible, okay? So don't be afraid if you are in that situation where you cannot file with your spouse or your spouse is no longer helping you file. And this is very serious these days, because these days everybody is anxious and stressed out about what's going to happen. So you may be feeling even more worried about what your spouse is going to do. So I want you to watch out for these warning signs, because sadly enough, we see it in some of our own cases. We do some joint marriage cases as well as a lot of VAWA cases. And this is, for a lot of reasons, sometimes I regret doing the joint marriage cases, because sometimes these cases, there's a lot of things that happen, and my clients end up not being able to do the joint case anymore because of something that one of the other clients has done. So I want you to watch out for these warning signs. If you are thinking about filing for a green card with your spouse, I have to tell you that it's not always as easy as it looks. So number one, if you're filing a joint marriage case, you are going to have an even higher burden of proof, because that's what the law holds you to. The government will hold you to a higher burden of proof. So you need to have lots of documentation. You need to have your spouse cooperate with you for the entire length of time, up and through until the interview, the end of the interview. And also, once you get your 2-year green card, you still need your spouse to cooperate with you for the following years thereafter until you file your I-751 and until you have your I-751 interview. So it's actually, it seems like it's a very easy and it's a golden promise, but it's not always the case. So here's what I want you to keep in mind. If you are thinking about filing for a green card with the help of a U.S. citizen spouse, but you're having some doubts, you're having some problems in your relationship, for me, what I have seen in many cases are these types of red flags and warning signs. And earlier in my career, again, I've been practicing immigration law for 15 years. So sometimes, I was a lot more naive in the beginning. And I would look at these signs and think that, oh, this is just a couple that's trying to be a problem. But that is not actually the case. If your U.S. citizen spouse does or says any of the following things, I want you to pay attention and think deeply about whether or not you believe in your heart of hearts that you're going to be able to rely on them. Number one, your spouse makes comments that, oh, maybe it's even a joke. Maybe your spouse jokes like, oh, you're only doing this because you want a green card. That is warning sign number one. The minute your spouse starts making jokes about that, to me, that means that they're already kind of thinking that maybe they're already doubting that you feel the true feelings for them. And something happens where they start bringing that up even more and more often the more and more you fight. Number two, your spouse makes comments about where you're from, about your heritage, about your language, about your customs. And they make comments that make you feel like you are inferior to them because they are American and you are not. Number three, your spouse makes a big deal over how much the lawyer costs, over what documentation that they have to provide. They make it a big deal that they have to do so much work or put in so much effort for your case, thereby making you constantly defend the process, defend your case, and feel guilty for even asking them for their help or asking to use family resources. Heck, maybe you're using your own savings to pay for the case and your spouse still makes you feel guilty, right? Number four, if your spouse fails to keep appointments with you and the attorney for the case, there are a number of appointments that you're going to have with your lawyer where you have to prepare the documentation, sign documents, review things, prepare for the interview. And if your spouse constantly shows up late or misses the appointment or gives you the runaround about why they can't come, that is a warning sign. Next, if your spouse starts demanding things, if they start saying that you owe them money, starts demanding that you do certain things, or starts literally outright saying that I'm not going to go to the interview unless you do X, Y, or Z, that is red flag number 5 or 6. I lost count. And if these things are happening to you, what I would counsel you is to not wait until the last minute. Do not wait until you get your interview notice and until your back is up against a wall to find out what your options are. Do not wait until you've gotten the interview notice or until you have that request for evidence with the deadline coming up to find out if you can file by yourself, because you can still convert your case at any point to a self-petition. But the longer you wait, the higher you chance the risk of a denial. And these days, if your I-485 is getting denied, then you are receiving a notice to appear in court, even if your case got denied several years ago, which we have been seeing in our office. A lot of our clients are receiving notices to appear for cases that they did before they even met us, okay? So the bottom line is that if you're in the situation, you see these sorts of red flags, you need to reach an attorney's office, and we would be happy to take your call to discuss what your options might be, because you deserve peace of mind. You know, a lot of times people are hanging on to these situations, praying and wishing that their spouse is going to get better, praying and wishing that somehow they can love their spouse so much that their spouse will automatically become compliant and not give them a hard time. But the reality is that when a person has that sort of feeling inside of them where they feel the need to manipulate and control, that's never truly going to go away. And you are going to be stuck bearing the results of that. And ultimately, you're going to be bearing the risks and the harms of that, okay? And, you know, I firmly believe that everyone deserves to have power and freedom in their lives, okay? So anyway, if you would like to talk about your case, you can give us a call, 212-248-7907. And I have a question here. During what stage of adjudication does USCIS confirm abuser versus citizenship? I actually got this question yesterday or the day before. So definitely it gets firmly confirmed after the prima facie stage, okay? All right, guys, so that is all the time that I have for today. Yes, Michael, I'm sorry we're not taking marriage cases at this time, although, you know, we're taking a very limited time and we've already reached our cap for this month, okay? Anyway, again, our telephone number is 212-248-7907. All right, we get an email about my brother every 6 days saying to wait for an appointment from Rod. Yeah, that sounds about right for a lot of things. Is it safe to travel outside the U.S. with a T visa? If you have a T visa, there's no advance parole, so you cannot travel. And if you do have advance parole through anything, through any sort of case, you have to be very, very careful about whether or, you know, deciding whether or not you should leave the U.S. and come back. It's kind of a risky time, you know, and you know, I think that we really need to see, like, wait until the end of the year, honestly, to see how everything's going. My hunch is that all the enforcement activities are going to get progressively worse through the end of the year, and maybe we might see a slowdown at the beginning of next year. I'm hoping, you know, hopefully it comes even sooner. So again, very stressful times, awful times, terrible times, unfair times, which is why if you are an undocumented immigrant, find out what your rights are right now, find out what you can do to try to protect yourself even a little bit and protect your life and freedom in this country, okay? 212-248-7907. Is VAWA only for a married person who has already filed an I-130, or can you file without it? From why? Why? Great question. You do not need to have filed an I-130 for a VAWA. But did you know that if you filed an if your spouse filed an I-130 for you many years ago, even if it got denied, even if you're divorced now, that you might still be able to recapture that priority date to file for VAWA now? And that means that if you got divorced many years ago, but your spouse filed an I-130 for you many years ago, even if your spouse withdrew it or it got denied, you may still be able to file for VAWA. This requires a close evaluation of the facts and the documentation to see if it is permissible, but in many cases it may be, and it may save your ability to proceed with VAWA, okay? 212-248-7907. All right, guys. Well, I hope you all have a wonderful night. Thank you so much for listening and joining. I know this is a very quick one, but it's also very late right now, and I'm trying to get home, okay? I hope you all have a wonderful evening. Good night, and God bless.